So we're back to you with In Your Best Interest. Today I've got Mr. Michael Rousseau. I call him the trial room, courtroom legend. And I know that's probably a little bit overkill for you, Mikey, but fantastic attorney. And we wanted to really highlight the role of basically a senior attorney and how you fit into the firm and how we fit and how we have a cohesive unit to tackle a case. So we'll just dive right in. So welcome, Michael. Can you kind of tell me basically how you got your start, your early beginnings in law, what drove you there, and what made you kind of choose family law, and kind of give the listeners your history, a little bit of that?
Well, thanks for having me, Justin. But I guess I always kind of knew I wanted to get into law, preferably in the litigation side, ever since, I don't know, high school even. And, I went to SMU, finished there.
What'd you study in college?
Business.
Okay.
I went to University of Georgia and got my business degree from Terry College of Business. I'm originally from Austin, went out to college there, came back up here to North Texas. After I finished law school, I wanted to clerk for a judge. It's generally, at least in law school, they tell you it's a good idea to go do that. If you can.
Is that like your first summer or what?
It was right after I graduated for the 3L. Actually, during law school, I clerked at a real estate law firm and did some real estate litigation work there. I mean, as an intern, it's not much. And then one summer, I also worked for Bank of America in their legal department. I thought I was going to go into commercial or business law at that point. Went to the clerkship out in the U.S. Virgin Islands. It's part of the Third Circuit. I know it's...
dude, how was that?
A lot of fun. Different. Different legal field out there, but it's also very litigious out there. So I was in the courtroom a lot, and that's when I realized that when I come back, I'm going to want to do litigation. I actually joined a litigation firm on St. Thomas, and then in 2017...
So when you say litigation, just kind of dumb that down. So what does that entail when you were doing litigation at St. Thomas?
In law school, they break it down. You can either go down the transactional route or the litigation route. I was just more keen and honed in on doing the litigation route, which is essentially, in layman terms, the courtroom. Lawsuits, people suing each other over a myriad of issues. It could be anything. Whereas, transactional is more, that real estate law, M&A, corporate business law, where you're dealing more with contracts. Not to say there isn't you have to understand contract law in litigation, but I knew I wanted to be in a courtroom. So when I moved back here in 2017 after the Hurricane Irma out there, I decided to come back and join a firm in Dallas. They do everything from insurance defense, commercial litigation, and I started in civil litigation.
Was there like a big difference? And I didn't mean to interrupt, but was there a big difference between the court style in the Virgin Islands versus this style here?
I would say out there is more it's more akin to family law in the States.
Okay.
So
it's a little Wild West.
Yes.
At times.
Yes, very much so. And that's what I liked. I thought it was more interesting. When I went to a firm and just was doing more civil litigation work and then some construction litigation, you rarely get in the courtroom. You do a little bit for certain kind of motions, but it's not what you're going to have to do in family law. And thankfully, that firm I was at, it was a larger firm, but they did have a small section dedicated to family law. And I just asked, I wanted to get more cases in that area to try it out. A lot of people sometimes veer away from family law in law school because it is emotionally taxing on attorneys and clients. The most similar one might be criminal law, some people say. But once I started doing that, I just immediately knew that's what I wanted to do.
Yeah, I was going to ask you, going from the esteemed court clerkships to the big transactional stuff that you've done to also the construction litigation, you pivoted to what I think captures a lot of the same litigation strategies. Were you able to pull some of your litigation strategies from other areas, real estate, business, pull that in?
Yeah, absolutely. And I think it's really important from just a procedural standpoint, because the one thing you learn a lot in just regular civil litigation is procedure, which is really important in Texas courts, essentially, in any court, really. And sometimes family law, I think sometimes when you jump right into it, it's so fast. It has a different operative style, and a lot of attorneys don't have that base experience about procedure and certain kind of motions you can file for summary judgment or other kind of motions that do apply in family law that aren't often utilized, that are very common in civil courts and civil litigation cases. So I think having that experience at first has really helped me understand the process from a litigation standpoint in family law.
Yeah, like using the rules of evidence. I mean, I think some people think that, doctors will be brain surgeons and heart surgeons, but they think lawyers should be able to kind of do it all.
Yes. Yeah, that's not it's not true.
We might know some procedural aspects of it, and we can carry that forward. But what's your thoughts on, like, I guess, being overly broad or having multiple, where you say, I'm the personal injury lawyer, the criminal lawyer, the family lawyer, having the jack of all trades? Do you really see the ability to keep up or stay abreast of what you need to know in family law specifically, especially with the personalities that we're dealing with?
Well, yeah, certainly. I think, especially in family law, it's people are like, oh, it's just dealing with a divorce, but it's so much more complex than that, because divorces are not one divorce. I mean, there's similarities between cases, but all of them are entirely different. People have different kind of assets, different estates, different issues, and being part, or at least being involved in civil litigation and understanding business law, you're going to have to deal. I mean, family law, you're going to potentially deal with all of those issues, and it's good to have a foundational background in understanding how businesses work, how a P&L works, how balance sheets work, how valuations work, and how businesses work, because you're going to face that in family law. And if you're going to be successful in it, you're going to have a good understanding of how that works. So having a general background in litigation and business, I think, has been very helpful in carrying that over into family law to understand clients' specific needs.
Yeah, you and I were in trial a couple weeks ago on an NFL case, and I'll get into that in just a minute, because I know people like to hear the actual, what do I do here and what do you do here in the courtroom. But from a preparation standpoint, we've talked a lot about, most of our cases get resolved in mediation. That doesn't mean we don't have temporary orders and agreements, and we're doing kind of mini trials. Can you explain what your approach is, or how you prepare from basically the time the client walks in the door through that first 3 weeks where it's like rapid fire into temporary orders phase? What your approach is?
Yeah, and that's something unique to family law, temporary orders hearings. You don't have those in civil court. They have temporary injunction hearings and similar basis on it, to get certain orders in place that, just so there is something for the parties to adhere to during litigation. But with family law, you have to treat a temporary orders hearing as if it is a trial. And, you want to be cost conscious with clients and what's going to cost. But like you said, most cases do settle in mediation, and that's in all areas of law, including criminal law. I want to say, so probably at least 90% do that. But you have to prepare as if you are going to trial, and that starts in the beginning.
Yeah, that's a great pivot point on the budgeting side. So you dealt with some very big contractual and commercial litigation cases in the construction arena, and y'all had temporary injunction hearings, which to the layman, that's our temporary orders hearing or temporary restraining order hearing, which happens very quickly. So tell our listeners kind of the cost difference between how we budget a temporary restraining order hearing. Just do a comparison for them. Like, how much would somebody spend on a temporary injunction hearing on a bigger case?
Well, yeah.
And what all's involved?
I mean, it generally depends. I mean, temporary injunction hearing after you file a TRO, when you start, which we do a lot in family law as well, about we want these immediate orders in place. Most counties in the area in North Texas and generally throughout Texas have standing orders, which are basically temporary injunctions that go into effect once you file and are binding on the party that filed, and they're binding upon the party served with them once they're personally served or accept service and waive issuance of that. But a temporary order hearing in family law, generally you're trying to, if it's a divorce case, you're trying to have temporary orders in place affecting not only property and debts and use and who's paying what and who's going to be staying where and using what during the litigation, but also all the custody related issues as well. So at family call it like a mini trial because you're effectively having your first trial in a condensed amount of time, covering a myriad of issues and trying to get all of that into place to set you up for your success during litigation. Whereas in civil law, it might just be one particular issue or a couple of issues to cover just to keep some status quo. And those hearings, I think, are less intensive or all-encompassing. So family law is
I
unique.
kind of laugh and cringe at the same time when I hear things like, well, it's family law, it's simple, like this is no big deal. But you've dealt with, and this is not just touting family lawyers back or patting us on the back, but you've dealt with complex commercial litigation issues where they spend, I'm assuming, hundreds of thousands of dollars on the temporary injunction phase. Is that accurate?
Yeah, they can, depending on how big of an issue it is and what they're trying to achieve within that period of time. But it certainly could be extremely expensive.
And you get like $5 to $7 grand to play with in the, if you're lucky, in certain circumstances, on the temporary orders phase, which you just said was sometimes way more encompassing as far as the evidence. Can you kind of walk through why there's so much more and how you have to condense it so quickly in a family law case?
Well, because you're trying to, within generally a 2 to call it 3 week period, you're trying to gather someone's life story essentially, or their marriage story, and condense big picture items into essentially a 30-minute presentation of your evidence. And I know that's a really difficult I understand why that's so difficult when people, clients come in and they want to explain their entire story and the life, and you really got to work on condensing and saying, look, depending on which county we're in, we might have 20 minutes aside, and you want to cover a massive amount of issues and talk about individual credit card statements and whatnot, but you really have to give a really good summary that's powerful to the judge to lock in on your position right there. And it's difficult. People are trying to gather documents and everything related to their kids, to their finances, to anything, and trying to get you all that information, us analyze that information, figure out how we're going to present that information, how we're going to counteract or defend against any allegations our way or against us, and try to get that, how are we going to present all of this within 20 to 30 minutes?
Yeah, so I get that question a lot from clients. Like, what do you mean I have 20 or 30 minutes or an hour on a temporary orders hearing? So that shouldn't be that challenging if you only have that much time. But what's your take on that? Like, if you get, a lifetime worth of stuff and you've got significant property and you've got real child custody issues and you've got to condense that down, how do you pick, or how do you advise the clients what pieces of evidence that you need?
Well, you have to understand, break it down with your client. What is the most important things to you? What are the 3 things that within the next couple weeks are going to be the most important things to you? We'll get to everything else. We'll figure out, issues might arise right after this, all the way up to trial. I can't anticipate that. But you really need to focus in and say, big picture, what are the most important things you need to present? Because, 20, 30 minutes, depending on how, witnesses are answering questions or trying to get evidence or documents into evidence, it goes a lot faster than people might expect. And the reason the courts put these limits on these hearings is because to the individual and to our firm, this is the most important case on the docket. It covers expansive, more important obviously than anything else going on. And I understand why people would believe that. It's their life. It's the most important thing to them. But these courts, they're backed up. There's so many other people that have similar or worse issues, and they're just trying to get this through. So you really got to be able to grab the court's attention. And they're people too. They're busy. Maybe some of the judges aren't fully paying attention the whole time because they're working on other cases while they're listening to yours. So you got to really focus on high, I guess, macro issues in your life that are going to just resonate with the court. And that's why having a law firm and a lawyer present the case, we understand what the judges want to hear, what they're looking for, and we can guide clients to, this kind of judge is going to be more interested in these issues. So if this is important to you, this is how we should present it.
Yeah. So on that note, like I talk a lot about never speculate, don't conclude. And, a lot of people come in and say, well, so-and-so's crazy, or so-and-so's wasting all these assets and wasting all this money. And, we kind of say don't speculate and don't conclude, and we need the actual evidence to be supported in a case, but we got to do it in a really short time span on these temporary orders. You and I were in trial, was it 2 weeks ago in Collin County, and it kind of feels like Bobby Fischer where they're hitting the stop clock for each side.
Yes.
And we were presenting multiple experts, big property, big child custody issues. And even then it was a trial where they limited our amount of time on a final trial. So can you kind of explain how you are, one of the things I tell the clients, this is a super long question, but one of the things I tell clients about you that I really admire, and one of the things I really strategically pair you up with is going to be the complex litigation where you're going to be in a courtroom, most likely. There are very differing issues. So how do you balance the caseload whenever I assign you a case? How do you balance when a client's calling you and asking you about things that are what you consider irrelevant, but also trying to make them see that you do care? Like how do you do that on a day to day?
Well, I think you can't tell someone because it's not irrelevant. I mean, a lot of what they might be saying, it's irrelevant in the context of what we're trying to achieve or for purposes of an actual trial, but it's not irrelevant to how they feel about the situation. It's not irrelevant to the important facts. It's, their understanding of their life and what they've, heard someone say or their speculations. And you really have to, I think, to connect with the clients and make them know you understand, we care. And I do. And I just don't try to be I'm not trying to be dismissive when I'm, talking about personal issues that they might be having with the case or their speculations or their concerns or their speculative concerns, and just let them know, that, if you have personal issues, a therapist is the best way to deal with that, or speaking to someone else that's a professional and how to, come to grips with your own issues, and really just trying to keep clients on track of what is really important here from a legal perspective and what we need to do to achieve what they want out of it. So I think really, to answer your question, you want to be able to be understanding with the client, but also let them know we need to focus in on these specific issues if you want to have a chance at a favorable outcome.
Yeah, and we get the thought a lot, well, if I need a man or a woman, or so-and-so's not listening to me as much. So how do you feel like our team is, I guess, designed or gathers around what I would consider the more highly emotional cases where, you're able to be free up to be able to go into a courtroom? How do you see, for example, Tiffany, our paralegal, interact with the clients, and how does that help you able to free up, I guess, and how do you balance the client's emotions in that process?
Well, I think it's one of the benefits of our firm is that we have multiple attorneys and paralegals that have different backgrounds and different personalities, different communication styles. And we're very good if someone, you said highly emotional, needs, or, has a specific, like a mother with young children. I mean, obviously I'm not a mother. I can sympathize with their situations, but I obviously don't have the personal relatability to what exactly they're going through. And like you said, with Tiffany, we have multiple attorneys at our firm that are mothers. We have paralegals that can be in that position. We have attorneys that are fathers, and we're an interactive law firm. I mean, I understand we assign cases to specific attorneys, but we've done it before. We have other attorneys step in to help on specific issues or to talk to clients about how they're feeling about what they're feeling at that time. And we work as a team in that regard, so we can cover all of it.
Yeah, I mean, I think that's the big misconception out there. I had a client call yesterday. We have people. Every business has staff turnover. They have people that have babies. They get sick. They're traveling. I think that there's a big misconception in family law and probably other areas of business that, like, the person that was assigned my case, if anybody else touches it, they don't understand. Mm-hmm. What's going on in the case. So can you kind of give some insight about how we deal with and what our processes are to be able to pick up and go on a day-to-day? Because we have things that derail all of us as attorneys, and we have staff turnover. We have things that exist. And how have you seen us deal with that situation at the Sisemore Law Firm?
The number one goal is to understand the client's case. And I think the best way to do that is through organization.
Mm-hmm.
And we're a very organized law firm. We track the cases, we keep notes, we have pleading binders, we have it on our server system. We have anyone has access within our firm, other lawyers, access to files. So if we need someone to step in to help with this, the case has already been organized. There's notes on our portal. They can jump in really quickly and understand the case. And additionally, all of our lawyers are constantly bouncing ideas off of each other for their own cases. So even though Ashley and Tanner, you might have a case that I've been working on, for the most of them, I have a general understanding of what's going on in that case just from our collaboration.
And also, like, I talk a lot, I probably beat clients up with the whole concept of timelines, using our billing to update the client, and inventories, because I'm assuming we're all the same in that we get some clients that just want to pepper us with a bunch of text messages and emails, and it's just they don't really know where they're going. So can you explain why getting the clients at the very beginning in chronological thought order and getting that timeline is helpful, not only because of organizing their train of thought when they're testifying in a courtroom, but also because of that need for having a bunch of hands on deck and eyes on the ball?
Yeah, and we really hone in on it. I mean, the chronological timeline is so important. It's crucial to understanding the case, and it also helps the attorneys understand it from that perspective, to where we need to go to present the case to a court. And I think if really explaining that to clients and having them, and I understand they're coming in, it could be highly emotional, they're lost, they're scatterbrained. I mean, I get that. It's obvious. I mean, who wouldn't be?
And it's stressful.
It's stressful.
You're in a freaking courtroom. It's weird.
And not only that, I mean, that they're trying to deal with all of this and then manage their day-to-day life as well.
Right.
Their job, kids. I mean, nothing, just because you're going through a divorce doesn't mean your life stops. So I understand why it can just be, you feel completely overwhelmed. But I think to really explain to clients that, to do their homework, and it's going to be rough. It's going to be time consuming. It's going to, on their end, but the more they can give us an organizational structure of their timeline, their documents, the background, the easier it is for us to collaborate within the firm. It's easier. It's going to be more efficient for us to figure out how to present their case to a court. And they have to understand that, look at it from not only our perspective, but a court's perspective.
Mm-hmm.
If they're disorganized in providing the information, our presentation is going to, in effect, be maybe somewhat disorganized as well. And then the judge isn't going to understand the case the way we want them to understand it. And sometimes when people, it's their life, they're like, well, I get it. Why can someone else not get it?
Yeah.
You have to understand, we have, it's not just, this is my only client, my only work. I'm working on, 50, 60 cases at times. And having an organization, having the client put the work in the beginning to really organize their case is going to be extremely helpful in their outcome in the long run, and for us to present it to a court.
Yeah, I think it's hard too, because, if a client doesn't get in the habit of organizing their thoughts and also the exhibits and making sure those are in admissible form, there's a lot of interruptions. Like our trial a couple weeks ago, I mean, we had, what did they give us? Like 4 hours, or what? And we ended up doing it for a couple days.
We had 2.5 hours aside for a case with multiple young children, a complex estate, complex fact patterns.
Now, was that our choice, by the way?
No. And the thing is, if you go and you make a jury demand and you have a status hearing or a pretrial conference when you're telling the judge, and both attorneys say, we're going to need 4 or 5 days on this, you might get it. The court might find some time, but the problem is they're going to push you. Like, yeah, we can get you in 2 years from now.
Yeah.
And most people don't want to wait 2 years living through the court system. So if it's a one-day trial, and a lot of counties, you get 2.5 hours aside. Granted, sometimes in cases, if the case is moving smoothly.
Yeah, just tell our listeners how many freaking notebooks we had for that.
like 15, 16.
Okay.
And they don't use them all, but
these are
yeah, massive notebooks of documents.
rim.
And you have to understand, I mean, think about it. In 2.5 hours, can I walk a client through a notebook of 8 years of credit card statements and then somehow tie that in and explain that to a court why the other party has been wasting funds, or why you've been spending too much money, or why you don't need spousal support, or whether or not there's been waste on the estate. You have to hit big picture points on that.
Yeah, so we had a controverting expert in that case on the property side. Can you tell our listeners just kind of what the difference is between these two experts, just specifically what they found and their differences of opinion and how that would have impacted the client?
Oh, and in that particular case, it was a commingling or a mixed characterized asset, meaning there's a portion of it that was separate property, meaning acquired before the marriage or by gift, device, descent, in this case before the marriage. And then the asset is an investment account or a 401k. It started to increase in value from the date of marriage moving forward. So that creates an issue.
And we had the NFL pensions.
Yeah, we had pensions. We had a different
We
kind
had
of
the disability.
Yeah, there's 4 or 5 different unique plans. And depending on which method and approach the experts were using to do a forensic tracing of those accounts, we were hundreds of thousands of dollars apart on some of those accounts as it related to which portion was separate property and which portion was community property. If it were, in our case, the higher it was in separate property, the less amount of funds were available to divide for the court, would have the authority to divide for the community estate. And because we were so far apart on that, we were able to work out. We made a decision to work that out where we think it'd be best for our client and mitigate any kind of risk. In trial. Yeah. We were allowed to step outside for 5-10 minutes after I don't even know how many hours going through this kind of issue. And then I understand why it's difficult. You're in a room with a client and we have 4 minutes. Do you want to make this decision or not? I know we've been preparing for this for over a year and a half, but this is what we're going to have to do.
They're offering effectively all the way up until trial and including in trial, basically no liquid assets and no cash. You just get this and take it and just walk away and you should be happy with what you got, kind of thing.
And, I think strategically, sometimes when people come in and they want to make a proposed property division, which you have to present to a judge before trial, this is my proposed property division. It's essentially a spreadsheet of all the assets, liabilities, who should get what, percentage breakdown. If you come in, I think, too aggressive, where you're trying to offer zero liquidity, zero real estate, you can have portions of retirement accounts that, in effect are going to have, maybe significant penalty or taxable issues if you divide that way. I mean, these judges aren't stupid. They can see what's going on there. And I think sometimes, maybe circle back to that, explain to clients, I understand that's what you feel is right, but we want to come off that we're trying to be reasonable to the court as well.
So even on our side, where we're representing somebody, we want to maximize value, obviously, but you sat there, you watched the cross-examination, and what was your perception when I was asking him those questions based on his relief, just raw, no?
Well, I think the court could obviously, because he wasn't as if he was lying on the stand. It's like, yeah, that's what I think we should do. And the court's going to understand that without even having to hit them with the last questions, or circular questions where you say, you lead them with this. So what you're saying is zero liquidity for your wife. And a court's going to see that and understand that it might affect that witness's credibility moving forward. And the judge is going to see that's not a just and right, fair and equitable division.
Yeah. And I think too, it's important to note that, when something is completely unreasonable as far as a plan or a proposed property division or a custody aspect, where you have the absolute person that's never been involved in the primary caretaking decisions ask for primary just because they don't want to pay child support, which is very common in our business, or in the property situation where they don't want to give the liquid assets and they want to give the assets that have no value as the proposal. If you make that unrealistic proposal, I think it's very easy for the judge to detach from that and go, okay, this one sounds reasonable and this one
Yes.
sounds unreasonable.
Yes. If you can explain your proposals and they're reasonable, and sometimes by being reasonable, that means you're going to have to concede or give up something, even if you absolutely feel 100% about one way or the other. That's just not the law sometimes. And you have to be reasonable from both ends. I mean, we were on the other side of the cases like that where we're representing the party in control of all the assets or who worked the entire time. And I can understand. I feel like this is the money I made. I'm the one that worked. I've been paying for everything. And I just don't think it's fair. I mean, that's one word you have to let go of when you're in court. I mean, I don't understand it's a legal term, fair and equitable, but yeah, it's also equitable. And there are laws and there's community property laws in Texas. And it's also advising from the other side, clients, like I understand why you don't want to do this, but you're going to have to propose, or, we advise you to propose dividing this fair, making it look fair. It's going to build you good credibility with the court and also in custody matters. Even if you absolutely believe I could be the best parent, I could be this, I know for a fact that I should have these, but the facts show I've never done any of these day-to-day caretaking for these children, specifically, especially very young children. You have to, even if you think your wife wasn't a good wife or your husband was a good husband or that they slighted you or cheated on you or were unfair, most have to believe that they will care about their kids. And you have to be realistic from not feeling how you feel about it emotionally, but what's happened. And that's just one thing I'll say. A lot of people have, because there's what if this happens in the future, or I want to prevent this because I think this might happen. And I mean, courts, they punish retrospectively, just as in criminal law. You can't say, well, for propensity even. I mean, courts could consider that and making a decision, but you can't say, well,
so and so is always going to be.
Well, yeah, he was violent, or I saw him punch a wall 3 years ago. So how do I prevent him being around our kids? I think he might do something like that. And unfortunately, the courts, they can't punish people for things that haven't happened.
And that's the tough conversation that we have to sometimes lead a client or steer a client away from.
Yeah, it's like, what's going to happen? Well, what if he forgets to pick him up from school, or if he isn't on time for all this? Like, can I prevent that now? And I'm like, well, the courts are going to give parents, unless there's direct evidence that they're a drug addict or have an extensive family violence history, they're going to give people a chance to be a parent. And you deal with those issues as they come. And it's difficult to tell a client, like, yeah, that's going to have to happen. I know you don't want it to happen, but the courts are going to give people chances too. So you got to explain and be very clear that this is the evidence we have. We think we have a case for this position. These concerns you might have in the future, you most certainly can testify you have these concerns, but we're not going to be able to deal with them through the judicial process until they actually occur.
Gotcha. Well, and that brings me to my final point. There's obviously a time and a place for pro se or somebody representing themselves. Is there any way in your mind that a case with any level of complexity, even if it's just a disagreement of a house, a disagreement of who should have the right to establish the residence within what counties, a disagreement about educational decisions, is there any real way in your mind that a pro se can navigate those waters the same way an experienced family lawyer or a law firm can?
No, not even a little bit. And I understand the last thing someone wants to do is spend money on their divorce. I mean, I get it. I mean, life's day-to-day life is expensive. Kids are expensive. You don't want to, if you wouldn't prefer not to spend money on an attorney in a divorce when you're effectively losing your net worth. But you have to view that from almost a business perspective. If it's a dissolution or a winding down, bankruptcy, court where you're going to be paying lawyers and you're going to effectively lose money. It's not like a personal injury case or a contingency case where I got injured, my lawyer, I don't have to pay, they get a percentage of what we collect. That's not applicable in these areas of law. So you really have to understand with a pro se, meaning representing yourself, unless it's a very, very simple divorce, no kids involved, you have a couple bank accounts or like a lease and y'all work really well together.
On
which is
all issues,
which is very rare.
Yeah.
The work where, if we run into a clarification issue or an enforcement issue post-divorce, we'll be able to work it out because we're doing fine. But that 99% of cases are not that way. So, you do it yourself. You're going to fill out these forms with custody, but, what happens if you don't put a geographic restriction in there? Something you might not even know about would exist. Even you can Google ChatGPT, but you're not going to know how it applies, what happens if someone breaks it. And then if you do it yourself, the orders, one, that you're going to enter are going to be vague. You're going to have clarification issues. You're going to have post-divorce issues with property division, closing documents, and future custody issues. And you might have a great case, and I see it all the time when I'm waiting for other cases to go forward. Someone might have a slam dunk case for a protective order or on a motion to compel discovery or whatever the issue is. But if you don't know the Texas rules of evidence and you don't know how to present evidence to a court, it's not going to get into your documents are not going to get into evidence, and the court can't consider it.
Yeah, and I think that's a good segue too, because
and ChatGPT and that you could it'll give you case law. It might explain to you process, but it's not going to teach you
how to queue it,
or how to present evidence, or how to prove up documents, or how to properly authenticate anything. And that's where and most importantly, you're not going to understand the court system, the judge's tendencies, and how they view certain issues. And you're really paying for a lawyer not only to present this in the correct procedural manner and to guide you and advise you on realistic outcomes, what could happen, but also for experience and expertise for understanding these judges.
And to get you out of your way. Yeah. I mean, it's like, if you don't understand the judges, and we have a client yesterday called and to try to hire us, and I said, we're just not the right fit because this party has already been into court 10 or 12 times on a pro se situation and has probably already made the judge not very happy with the positions that this person was taking and wants us to come fix it, like the plastic surgeon that's done 8 nose jobs, and they go, your nose is going to look like that because you've done it this many times.
And that's another issue where I think a lot of people at first they're like, you know what, I'm going to give it a shot per se. I think I can do it. And then they dig themselves a hole, or they've lost out on presenting certain evidence, and then they hire us halfway through, and we have to almost start back from the beginning and see where we got to. And there might be some things we can't fix at that point because there's laws about modification. There needs to be a material and substantial change in a circumstance since that last hearing. And just to hire us at that point and say, well, give it a retry, you can't do that.
Yeah, and the lawyers out there, there's a lot of good ones, but there's also some not so good ones, right?
Yes,
and
sure,
so
just like any job.
Totally understand when a pro se or somebody wants to represent themselves. They're like, my last lawyer didn't do anything. We hear that a lot, but there is a situation. There's a lot of situations where many things are done behind the scenes in our business, and I don't really love hearing my lawyer did nothing. Now, sometimes it's true, but there are a lot of things that happen to get from point A to point B, and they just haven't gotten to point B yet.
Yeah, and
right?
And that is certainly true. Well, when people take that position where my last lawyer did nothing, or it's all my wife's fault, it's all my husband's fault, it's my mother-in-law's fault. They're a narcissist. I mean, that's a big word used in almost every single consult, and I'm not trying to be remiss about it, but that's not like everyone. And most people in these courts have narcissistic tendencies when they're going in there, and people generally don't know what that term means. And I've had a lot of courts say, I want them to take a psychiatric evaluation. It's going to show they're a narcissist, right? And they think that somehow the court's going to therefore say, you're right, you should get all the assets and everything.
Yeah, have you ever had
children.
A court go, hey, you're right, they're a narcissist?
No, I've seen people pay.
I've never even heard like a court make it. I've obviously their actions,
yes,
that are narcissistic tendencies, or they really get to narcissism, can lead to a court concluding that person shouldn't be the primary caretaker or should have some supervision. But I've never heard them go, you proved they're a narcissist, so here's the children, or here's all the money.
And also, you have to correlate this narcissistic even if you get a psychiatric or evaluation, you pay a ton of money for an expert to prove, yes, this person was coerced and they have narcissistic personality disorder. If you have no evidence that has in any way negatively impacted the children or led to anything bad acts, essentially, it doesn't matter. I mean, there's a lot of people that have narcissistic personality disorder that are highly successful and do well and are good parents. And I think, and I've had even judges say, look, y'all want to do psychological evaluations because y'all think each other are crazy. Go ahead, y'all pay for it. I've never found this was a quote from a judge in Tarrant County. I've never found these to be particularly helpful, but if you don't want to spend the money on it, go for it.
Yeah.
So I think those are only, it's important if you think, if psychological issues that people think they have, I mean, general anxiety disorders, when I see come back all the time, who isn't anxious? They're going through the most difficult time in their life. They're going to come back maybe with things like that. But really, unless you think someone's schizophrenic or
medications,
bipolar, like a severe mental issue, and it's untreated and they're not dealing with it, and you have specific evidence to show they acted this way due to this, mental episode, then they can be very important. And you have to do, if it's endangering or it could be potentially endangering to your children, I understand why they're necessary to go through with. But really, you got to focus on, these judges are probably going to give us a chance, and we need to be realistic about outcome. And that can guide us. And once I think clients can get into that mental space, and sometimes at first it doesn't happen, and sometimes it happens 80% through the litigation process where they've come to terms with it. And generally the other side does as well. And that's why we, a lot of cases end in mediation, because, the tempers are down.
Over the big hurdle.
The big hurdles are down, and they want to move on with their lives.
Well, great stuff. We could go on for days, and we will come back at you with a lot more scenarios and trial scenarios. Michael Rousseau here, guys. If there's any questions you have, please do not hesitate to schedule a consult with our office. It costs you a minimal amount of money. I feel like we give you a great amount of information. We've had a lot of positive client feedback. 817-336-4444, or you can reach us at lawyerdfw.com. We've been around a long time, and we can certainly help you with these issues before you spend the big bucks, or maybe steer you in the right direction of hopefully not having to navigate the litigation waters. Thank you very much.